All right, we are ready to get started. Welcome everyone to Marble's first webinar. Today we are doing a community Ask Me Anything session with Principal Attorney Jeffrey Pollak. And on the agenda for today, so we're going to kick it off with a couple introductions, a couple housekeeping things. We're going to do an introduction for Jeff as well as about Marble. Then we'll get into some questions provided by the community during registration. Jeff is going to walk through some answers for these. And at the end, we are going to open the forum via chat so that you'll be able to ask some more questions. After that, we will go ahead and select the 25% off legal services with Marble winner and just wrap up with some closing statements. So to kick us off, just a couple housekeeping things around Zoom. So for privacy purposes, please update your Zoom name to first initial last name. Your microphone and camera will remain off for the duration of the webinar, and chat will remain off until we open forum at the end. At that point, you'll be able to ask questions directly within that chat. For privacy purposes as well, when asking questions, please avoid sharing names of parties involved with your case and any other identifiable details. And as mentioned, we will be selecting a winner to receive 25% off legal fees with Marble at the end of the meeting, and we will send this presentation along with the recording after the webinar. All right, so I'm going to kick it off by introducing you to Jeff. Jeffrey Pollak is a California licensed attorney and the principal attorney for Marble. He has over 15 years of experience providing quality legal services to a diverse group of individuals and businesses. With an emphasis in business, real estate, and family law related matters, both litigation and transaction based, he's had the opportunity to counsel clients in a wide variety of matters spanning across the legal spectrum. With his pragmatic approach to the practice of law, creative problem solving, and a focus on always putting the client needs first, Jeff has helped Marble take great strides towards our goal of making legal care accessible to everyone. So welcome, Jeff, and thank you so much for being here today.
Thank you, Amanda. Thanks for that warm introduction. I really appreciate it. It's great, really great to see so many people logged in today. And I want to say I'm surprised, but frankly, I'm not. Even when things are friendly and amicable, being involved in a family law matter, whatever the issue might be, for most people probably feel scary and sad and it gets you filled with anxiety, which I completely understand. All those negative emotions, at least to me, they mostly stem from there just being so many I don't knows and what ifs and all the other I just don't know. And the reality is, though, while it seems like the whole process is complex and complicated, and it is, and sometimes the details make it even more, the reality is that the issues in a family law case are usually pretty straightforward. Knowledge, it really is power. And unknowns always seem like the scariest place to be. So, I just want to say I'm just really happy to be here, try to demystify some of these family law issues for everyone. I don't know that every person's specific question is going to be answered, but there's so much overlap. So I feel really confident that even if, someone's question is not answered, it probably will be answered, maybe even multiple times in multiple ways. And, look, one final word before we get started, and it obviously goes without saying, but I just want to make sure everyone watching and listening, you all understand that nothing I'm saying today should be looked at as legal advice that's applicable to your situation or any particular situation. Even if one of the questions I'm answering might be one of yours, everyone's situation is unique. There are so many follow-up details that I would end up asking if a person asked the same question I'm going to be hearing and or answering today. If they were in my office or we were on a Zoom and they asked me this question, I would have a lot of follow-up questions because the details are really what's important. So, I think everyone just needs to remember that your situation's unique. Make sure you speak with a licensed attorney and get whatever help you need. But you also most courts have a family law facilitator's office in the court, and they're there to help and provide guidance. They're not attorneys and they can't do it for you, but they will give you the information that you need if for whatever reason you choose not to go with an attorney. So I guess that's it. Should we kick off, Amanda?
Yeah, great. Thank you so much, Jeff.
Yeah.
And then before we dive into the questions, for those of you who may not know much about Marble, I wanted to give a quick overview of who we are. So Marble is a new kind of law firm that believes everyone everywhere deserves access to remarkable legal care. With a fast onboarding digital process, a flat fee upfront price with the option to pay over time, and a dedicated team of attorneys and case leads who put their clients first, Marble has reimagined legal services to provide people with an easier, transparent, and more human experience when they need it most. So Marble is currently available in California, New York, Texas, and Arizona, and we continue to expand nationally. And if you're looking for more information, please feel free to visit themarbleway.com. We'll make sure to send all this information after as well. And without further ado, we can kick off with the community questions. As mentioned, these were submitted during registration. So we went through and pulled some recurring topics for Jeff to answer. So the first one is from Mike in California. And he asks, how is child support calculated?
So that's a really good question. And it's a question that most people, I think, have, particularly, of course, if you have children. I think the thing to remember is that there's underlying principles that always come into play whenever you're dealing with the issue of child support. And it's not always just money, but understanding what the principles are can sometimes help understand why the process is done the way it is. The state of California, every state for that matter, but I'm speaking on, as it relates to California law, the state has an interest in making sure that parents are the ones who have the primary obligation to take care of their children, that it isn't other people who are doing so. And so that is really why, ultimately, at the end of the day, in most cases, child support's going to be ordered from one party payable to the other. It's not always the case. If parents, earn an equal amount of money and they have the children an equal amount of time, then there really isn't that need for it. Each parent is still going to be primarily responsible for taking care of the needs of their child equally, if you will, in that scenario. But understand that even though both parents are required to take care of the child, have a responsibility to do so, that doesn't necessarily mean that they have to equally, that they're responsible for equally taking care of the child. These situations happen for many people that are here today, probably, where one spouse just earns more money than the other spouse does for a variety of reasons. And so you have to understand that even though both parents have an obligation, a mutual, both of them have this obligation to take care of their kids, it may not be an equal obligation monetarily. The goal of a court is to make sure when entering a child support order that whatever that order is, it's fair and it's sufficient to take care of the needs of the child. That's the key. It is complex in terms of how that number is how the court comes to that number, but it's okay that it's complex, excuse me, because, and you can see there's a complex mathematical formula that's on the slide here. Nobody uses this formula by taking out a paper and a pencil and actually a calculator and working out what the numbers are. These figures come from the family code. People have developed child support calculators. There's the one that's most prominent is DissoMaster. The courts use it. Family law attorneys use it. You plug in the information like the parent's income, what various deductions they have, how often, how much time a child spends with each parent. And at the end of the day, after putting in all that information, the program essentially outputs what the amount of the child support should be and who it needs to be payable to. Of course, if the parents can agree on things, that's ideal. You're going to kind of hear me say that, I think, many times today. Sometimes it can't happen, but it is always preferable for parents to agree on every issue or as many issues as they can. I think it's better for the children. I think it's better for you as the parents, not having acrimony, not having the situation where there's constant friction and fighting is more peaceful for your own lives. It's definitely more peaceful for your children. I'm saying that as a father myself. I'm a child of divorced parents. And I can tell you that it is far superior for parents to find a way to agree on as many things as they can. It's going to be less expensive. It's going to take less time, and your lives are going to be more enriched and fulfilled because of it. And so will your kids. So there are times where if parents can agree on what that number is, it may actually differ from what this calculation would output. That's okay though. As long as you can show the court that the children are going to be adequately provided for based on the number agreed to, the court with a smile on their face, that judge is going to look at the document you guys agreed to and signed and the court's going to sign it, because it's always better to agree on things than it is to fight about it.
Awesome. Thank you, Jeff. All right, so question 2 is from Lambert. How do you finalize a divorce when the other party doesn't want to sign and cannot be found?
That's a good question. And parts of this happen all the time. But really this question is kind of 2 questions. The first one is, what happens if somebody doesn't want to sign something that's been agreed to? And the second one is, how do I even start this case, and how do I finish it if I can't even find the other person? Forget about getting them to agree to something. I don't even know where they are. Let's maybe start at the beginning and say, I think everyone needs to understand that, at least as far as California is concerned, and many states are this way as well, it's what's considered a no-fault divorce state. And what that means is you don't need a reason to want to dissolve your marriage. You don't need a reason to want to be divorced. Based on California's perspective and law, if you want a divorce, you're going to get a divorce, period. You don't have to show infidelity. You don't have to show that, your husband or your wife was abusive to you. And many people think you do. And they say, well, they cheated on me. I need to get a divorce. That is not nice. It's terrible. I'm with you. And that's certainly, in my mind, maybe a good reason to get a divorce. But you don't need to have that reason. It's not, from the court's perspective, it's not relevant. In fact, people that come into court saying things like that, the court's going to say, okay, but it's not relevant. Of course it's relevant to you. I don't mean to minimize it, but I'm saying from the process of a divorce, not relevant. Mm-hmm. Now, the first part of this question, which is what if they don't want to sign, it kind of presupposes that there was some agreement reached and it was put into writing, and now they don't want to sign. Here's the thing. If they don't want to sign, then they don't sign until a settlement agreement. It's called an MSA, or a marital settlement agreement. If parties to the case can agree on everything, then this marital settlement agreement, this MSA, will be drafted. And if the parties sign, essentially the court's going to sign that too. And that will now become the divorce, the disposition of all the things that came up in the divorce. But if they don't want to sign, then they don't sign. They don't need to sign. But don't worry. There might be some cause for worry, but I say don't worry in the sense of that's not going to be a holdup to getting a divorce. If there's some agreement and now a spouse won't sign it, then you're just going to proceed through the court system, and the judge is going to decide for you. And that's why, kind of jumping back to the last question, that is sort of an up in the air proposition. Maybe all the things you want, the judge will award you. Maybe none of the things you want, the judge will award you, or maybe it'll be somewhere in the middle. My philosophy as a person always is, take as many matters into your own hands as you can and try to resolve it in a way that is satisfactory. Maybe not perfect, but satisfactory. And that doesn't apply to everything. Sometimes, you got to dig your heels in on certain things. So that's the first component. The second one is, what if they can't be found? This also happens. Look, to start a divorce case, to start any lawsuit, if you will, you have to file, along with that first document you file a document called a summons. That summons, when it gets returned by the court, it must be personally served on the other side. There's something called due process in a divorce case, just like in other actions. A court is going to, at the end of the day, decide what's going to happen in these people's lives. Who's going to have to pay who money? Who's going to get the house? Is the house going to be sold and the proceeds split? Who are the children going to go with, et cetera? Okay. The only way the court has the power to affect anyone's lives is if the court has what's called jurisdiction over them. And the way to do that is to serve them with the summons. If you can't find a person because they're hiding in the bathroom, or they know that they've got a Ring camera and they see when someone comes to the door, and I'm not going to answer that door, they'll never find me. That is a really bad decision for that person to make, because there is a process, of course, otherwise everyone would do this. There's a process where if you can't find somebody, you ask the court to allow you to serve them by publication. Which means publishing in a newspaper. That person's never going to find out about the case. But once that service is complete, the court now has jurisdiction over them, and you can get what's essentially called the default judgment, which I think we'll get into a little bit later. And essentially the things you've asked for in your petition for dissolution of marriage, as long as you can prove them, the court's going to grant them to you. And the other person doesn't get to participate. That person we couldn't find, they don't get to participate in that lawsuit anymore.
Thank you. Yeah, this seemed like a recurring topic. We've got some other great questions coming up around that as well. This next one from Kieran asks, what are grandparent rights and how can I get visitation with my granddaughter?
This is a question that a little surprising to me, how often we get this question, not just in response to this webinar, but also just in our practice. Part of me is surprised, part of me isn't, because this, grandparent-grandchild relationship is really special. I know how close I was to my grandparents. And so I can only imagine the pain that it must cause a grandparent to not be able to see their grandchild. Understand that in California, I think because the policy of the state is to understand how special that relationship is. The state of California, unlike other relatives, grants grandparents this unique power, this unique right to ask the court for reasonable visitation with the children or a child. But it's not easy to do. And by that, I mean, it's not complicated. It's not like running a marathon or anything. You need to, there has to be certain elements, certain factors that actually exist for the court to be able to grant it. So that first one is that in order for a grandparent to ask for reasonable visitation with a grandchild, they have to be able to show the court that there was a pre-existing relationship that has what the court, what the law views, it calls an engendered a bond. And what that really means is that the grandparent is showing that I have such a special relationship with my grandchild, and my grandchild has such a special relationship with me that not preserving the relationship would not be in the best interest of the child. And I think it's a theme in California law, and you'll probably hear it quite a bit, me say it quite a bit today. When it comes to matters dealing with children, the court's going to always look at what is in the best interest of a child, not what's in the best interest of a grandparent, not what's in the best interest of a parent or friend or an aunt, what is in the best interest of a child. And if you can show that first part as a grandparent, that there is this engendered bond, it's not enough. You also have to be able to show that when the court balances what's in the best interest of the child, they have to balance that with a parent's absolute right or almost absolute right to make decisions concerning their children themselves without external influences. Just because of their own parent, the grandparent, just because the parent's parent doesn't agree with a decision the parent made, doesn't mean all of a sudden the grandparent has rights. Some parents, and it may be objectively unreasonable of them, they might say, I don't want you to see my child. I don't want you to see your grandchild. That's hurtful. That's sad. But the state recognizes that parents do have a right to control what things and people their children interact with. Now, as a general rule, if the parents are married, you're really not going to be able to get grandparents' rights, because you now have two parents and they both agree that they don't want you to see their kid. Again, there could be good reasons for it. There could be awful reasons, or what most people would consider awful, like my grandpa loves the color blue. I can't believe it. And I will never let a person that likes the color blue see my child. That is, to me, objectively unreasonable and ridiculous. If both parents are married and the parents are just wacky, how could anyone not let their child see their grandpa because he doesn't like the color blue? The court's going to say, sorry, I'm sorry. The parents have a right to make this decision. And there's some exceptions, and you can kind of see them in the slide. And we can get, we could get deeper into it, but by and large, they're fairly self-explanatory what those exceptions are.
Thank you, Jeff.
Yeah.
All right, this next question is from Lorraine. She wants to know, can you explain everything entailed in a joint legal custody? We ask.
I don't know if I can explain everything that's entailed in joint legal custody, but I can try to shed some light on this issue. I think before we even jump into the specific question, which is what's entailed in joint legal custody, I want to make sure, because I know that many people don't know that there are different types of custody. And even though this one's talking about legal custody, I think it's worth kind of breaking them out just so that there's an understanding. So really in California, and I want to say in every jurisdiction, but I don't speak to other jurisdictions, there's two types of custodies. One is legal custody and the other is physical custody. When we're talking legal custody, what that means is the person or parents, if they have joint legal custody, who get to make all the important decisions about the health, education, welfare of their minor child. So we're talking about things like, should they be vaccinated or not vaccinated? What religious school will they go to? Not only what religious school, in what religion will they go to religious school in? Do they need treatment for a medical ailment? Am I going to take them for treatment for a medical ailment? What are the different treatment options? Which ones should we choose? Those decisions get to be decided by the person who has legal custody of the child. If both parents have legal custodies, otherwise known as joint legal custody, then both of them are able to make those decisions. Now, obviously, we get a problem when you have joint legal custody awarded to both parents and they don't agree on something. Each one of them has the power on their own to take any of those actions, to agree or not agree with the vaccination, to take the child to get vaccinated, even though the other parent doesn't agree with it. Just using that as an example. That's a problem. It's a right that each has, but it's going to be a problem in this family law matter. It's going back to this whole being able to agree on things and not being able to agree. And though that would be an example if the parents can't work it out. And let's face it, parents that are married and have a happy marriage don't agree on everything. They don't. Even more so for people that are deciding, you know what, I need to have my marriage dissolved. The people at the end of the day that really are hurt in these types of situations are the kids, because they see their parents, who they both love, not loving each other very much, not liking each other even. You're going to end up with kids that are manipulative. They're going to feel hurt. They're going to feel like it's their fault, etc. And then what you're going to end up with is, since the two parents, the two adults, were not able to agree on this, now we got to go to court. Now we got to go tell the judge, hey, judge, I told him I didn't want the child to be vaccinated. I told judge, I told him I wanted our kid to go to a Catholic religious school and doesn't want to send them there. And then the judge has to decide. Again, now the decision's out of our hands. We can do it. We can put our best foot forward. Hopefully get an attorney that's going to really, vigorously advocate for your position. But ultimately, it's kind of a coin toss. You never know what a judge is going to say when you don't reach an agreement. And in fact, judge in courtroom A might, same facts, same attorneys, same parties, same papers that are submitted. Judge in courtroom A could come up with a different solution and a different order than the judge right next door, 100 feet away. Different solution. So you just don't know. You can have a good idea. You can cross your fingers and pray and hope. But once you don't agree on something, the power has really been taken away from you. So that's legal custody. On the physical custody side, that's really more straightforward. It's just, who's this child going to reside with primarily. It has nothing to do with making decisions for them at all. And as you can see sort of in that last bullet point there, these aren't mutually exclusive. Sometimes you could have joint legal and joint physical. Sometimes you could have sole physical, but joint legal. And it's just a function of what the facts are in every particular case.
Thank you. Great. So question 5 is from Angel. And Angel wants to know, if there is a great disparity between spouses' income, does the person with the greater income pay for both attorneys?
Well, I guess the only way to answer that is maybe. Right? That's the first word you see there on the slide. And I apologize. I might annoy many people here by just answering lots of questions. I don't know, maybe, depends. But unfortunately, that is the way it works. Kind of as I said at the very beginning, every case is fact specific. Every case is unique. A minor detail might make a big difference in what would happen in the outcome of whatever the issue might be. So the law does allow for a spouse to ask the court to order the other spouse to pay for their attorney's fees. It's just a right. It's a right you have. Whether you're entitled to it or not, you're allowed to go to court and ask that. The same can't be said for everything. You can't just go to court and ask the court to do anything. This is one of those things you specifically can do. I think the important thing to understand also is that while there is a process for making the other spouse pay your attorney's fees as a punishment because you engaged in bad behavior or you intentionally stalled the process or didn't produce documents you were supposed to produce, That's called sanctions. That's a punishment. When you, in the family law context, when one spouse is asking the court to order the other spouse to pay their attorney's fees, it is not designed as a punishment. And it's not designed as a reward either. The purpose of this being specifically and expressly allowed in the law is to level the playing field. The law, the courts, the judge, they don't want a situation where one party walks into court with the best attorney in the world, and the other person walks into court, they can't afford an attorney because they don't have a job, or their credit cards were taken away from them, or who knows what the situation is. And clearly one person is at a major advantage in that scenario, which means on the flip side, someone's at a major disadvantage. Court doesn't want that. The court wants, at the end of a family law case, for things to be as equal and equitable as it possibly can be. Okay. So what the judge is going to have to do is consider certain factors, like what are the income of both parties? What are the needs of each of the parties? Does one person have access to more money than the other one? And they're going to use it to retain a lawyer. And of course, okay, if I make this person pay for both people's lawyers, is there enough money to pay for two attorneys, for example? Now, it really is a fact-specific inquiry. So I'll give you an example. It's not just the fact that one person earns more money automatically entitles the other person to have their attorney's fees paid. Imagine a scenario where you have one party earns $100,000 a year, and the other party, the other spouse, earns $25,000 a year. You would say, well, sure. I mean, why? Of course, if that person has a lawyer and the $25,000 income spouse doesn't, of course the other spouse should be paying for their lawyer. Well, what if I added to that the person who earns $25,000 a year also has, from before marriage, a home that's worth $2 million, and it was just sold. So they're now separated. All that money is separate property of the spouse who earns $25,000 a year, but they have $2 million sitting in a bank account somewhere. That's going to clearly make a big difference. So, we could go down the road. I don't know what a judge would decide in this case, because I promise you, these are not the only facts that exist in this hypothetical I'm bringing up, but that obviously changes the scenario and would change the analysis.
Thank you, Jeff.
Yeah.
Question 6 is from Tequila from California. Are fathers less likely to be awarded custody than the mother?
It's a really good question. I want to say no, and I can say that definitively as it relates to like what's called the black letter law. The law says no, emphatic no. It explicitly says that a judge is not to provide any custody preference to anybody based on their gender, based on their sex. It is irrelevant in the eyes of the law. And look, I think that makes sense because there is not a one size fits all answer to a mother is always a better parent than a father, or a father is always a better parent than a mother, or the flip side of that one is always worse than the other. Again, the key here for the court in looking at every single case is going to be what is in the best interest of the child. Is sole custody to mother in the best interest of the child? Is sole custody to father in the best interest? Is joint in the best interest? And understand that the state of California has a policy, it's a policy of the law, that every child has frequent and continuing contact with both parents. There are exceptions to that, of course, like domestic violence, sexual abuse, physical abuse, things like that. Of course, that policy is now trumped by the safety of the child and the welfare of the child. But as a general policy, frequent and continuing contact with both parents is the ideal scenario, which should mean joint custody should go to both people all the time. That's not what happens. But that is the policy. The real key here is going to be, the inquiry rather, is going to be who's the best, because we're looking at best interest of child, who's the best parent here? If we've got to choose one, who is the best parent? What has been the mode, the MO of parenting for this child in this child's life? If mother misses all birthdays and works until midnight every night and is on work vacations 25 days, not work vacations, work travel 25 days out of the month. It's not that they don't want to award mom any custody or joint custody. It's just that mom doesn't have a history of being a true caretaker for this child. That's no blame. There's no blame that's imparted there. That's just sort of the reality of the history of the case. I think the thing to remember is, what was the relationship like between that child and each parent before there was a separation? And when the court's looking at things, they're also going to say, you know what, if I award that parent sole custody, do I think, this is in the court's mind, do I think that they're going to use that as a power play against the other parent and not cooperate? Do I think that they're going to use that as leverage or an advantage? And if the answer is yes, in the court's mind, if the answer is, you know what, that person's going to not drop the kid off when they say they are because they're mad at the other parent, there's a pretty good chance custody is going to be changed in a case like that if it was awarded, because the court's not going to be very happy to see those kind of things. Now, I'll say sort of one final thing on this topic, which again is a dad less likely to get custody than a mom? Look, I have 3 children, so I understand what it is like to have children you love very dearly and think in your mind, I'm not going to be able to see my kids every day or the way I used to. The reality is, sadly, you're probably not, whether you're a mom or a dad. Divorce is not fun. It is not fun. And you're probably not going to see your kids every day. That's just the reality of no longer being married and likely living in separate homes. But as a father, even though I know this is the policy of the law, I can tell you that if I were going through a dissolution of marriage action, I'm not, I'm happily married, but if I were, I would be concerned, because judges are people like you and me. They have biases just like we all do. They don't intend to, maybe they're not even aware of it. But in my mind, I'm always more concerned when I represent a father in a custody dispute over a mother, that there might be some of that inherent bias, not because the court wants to do that. And I believe strongly the court knows they shouldn't. It's just always inside of me that I have that concern, that moms are moms and dads are dads. And there's like a long-standing view of that. So I guess my guidance here would be, I think everyone needs to put their best foot forward whenever they go into court on an issue, no matter what the issue is. I highly recommend everyone goes into court for any matter, family law or otherwise, with an attorney who can represent them. That's what attorneys do. They're uniquely qualified to advocate for other people, and use their legal skills and their skills of argumentation to convince the court and try to persuade the court to do what we want. And I think it's, in my mind, even more important for a father for the reasons I outlined. I think it's it is equally important to mothers and any other litigants, but I think particularly fathers should be concerned and be aware. That's just my personal opinion, not my legal opinion.
Thank you. All right, question number 7 is from Tiffany, and she wants to know, how long does it usually take for a family law case involving custody? A lot of questions around custody.
I hate these questions that relate to how long is something going to take, not because I don't want to answer it, but because it's the most common question, one of the most common questions, and it's almost impossible to answer. I mean, it really is, because it just all depends on whether or not the parents are going to agree or disagree with what the custody arrangement is going to be. And it's not a one and done scenario either. I mean, parties can agree on everything having to do with custody except for who's going to have the summer breaks, for example. I think someone who can agree on everything but the summer breaks, we could probably, with good advocates on both sides, we should be able to come to a solution. It doesn't always work that way. I've gone into court for for very ridiculous things, where everyone on this Zoom would say, no, come on, there's no way that anybody dug their heels in on that. They do. Usually it's not because they care. It's for other reasons. But in any event, it doesn't have to be a one and done. So if you agree on everything except for the summer holiday, you're going to make that case and the duration go way down. In all likelihood, the time and expense is going to go way down as well. Yeah, you haven't agreed on everything, but the more you can agree on, typically less frustrating, less expensive, and less time it's going to take. If you agree, it's very simple. Essentially, you have an attorney draft what's called a stipulation. It's fancy word for an agreement. Both parties review it, talk to their lawyers about it, make sure it says what they want it to say. Both parties sign. When they do, that's a contract. As between those two parties, that's their agreement. It's not an order of the court, though. And that's always preferable, is to get an order of the court whenever you're dealing with a family law issue. That at any point in time was, there was some contest there. It was contested in some way. But what happens is you take that stipulation, you present it to the judge, and the judge, again, with a smile on their face, says, I'm proud of you guys. Fantastic. Good. Stamps it, signs it, and now you have an order. That's going to be much quicker than if the parties don't agree. I still can't say how long that's going to take, because it all depends on the county. What county is this in? Every court, the California court systems run county by county. Every court has their own rules. Every court has their own delays, their own budget shortages. They all have their own, processes, if you will. And some of them are very backlogged and it's going to take long. And some of them are, they're right up to speed and they're going to just bump it right through. If you disagree, it's a whole nother story. If there's a disagreement, again, now you got to go to the judge and say, Judge, we can't agree on custody. What's our custody arrangement going to be? You start that by filing what's called a request for order, or an RFO. When you get those papers back, you're going to get a court date. The court date's probably going to be 2 to 4 months down the road. All depends, again, on the court. Now, in order to notify the other party and force them to come to court, you have to serve them with that RFO. Because custody is involved, in California, every time there's an issue of custody, pretty much every time, the court will send you to what's called FCS mediation. Some counties call it something a little different, but let's just call it FCS mediation, Family Court Services. They're going to send you there. There's going to be an FCS mediator that speaks with each of the parents, gets a deep dive understanding, and I'll put some quotes over deep dive, understanding of what's going on with the parents, what's going on with the kids, background, all that stuff. And all that happens before the hearing date that you were given originally. And then that FCS mediator is going to prepare what's called an FCS report. That FCS report is going to make recommendations to the judge of what they think should happen in this case. And I will say that 9 times out of 10, the judge is going to go with whatever that FCS mediator said, because the judge doesn't have 4 hours with the parties in court. Typically, the judge has 10 minutes each side to say what they want to say. And so they're going to presume that this FCS mediator, whose whole job is to just talk to parties and try to develop a custody plan, that they know better than the judge does. They had a better opportunity to investigate. That's a little scary because we just don't know what the outcome is going to be when you don't agree. But the thing to remember, so even though if you don't agree, it's like maybe 4 months between filing and the hearing date, the court has jurisdiction over custody matters until the minor child's 18 years old. And so you can be consistently back in court over and over again if there's custody disputes. Again, not everyone is able to come to an agreement on things. And sometimes it has nothing to do with whether you are reasonable or unreasonable. Sometimes other people on the other side, your spouse, your ex-spouse, is just not reasonable. I would challenge everyone to ask themselves at all times when there's a dispute between them and their spouse or ex-spouse, is this really me objectively feeling that they are being unreasonable? Or am I digging my heels in on something that this just makes me angry about this person? I can never answer that question, but I really think it's important for everyone to answer that, because it can fundamentally affect the entire future of the case, but also, again, your peace, your tranquility, your children's peace and tranquility.
Thank you. And it looks like we have time for one more community question. We do want to have time to get to the open forum questions. So the last one from this list is from Susan. And Susan would like to know, can my 11-year-old decide who she wants to live with?
That's a great question. I guess the most straightforward answer is no. They don't just get to decide who they want to live with. However, again, going back off this, what's in the best interest of the child standard, which guides everything the court's going to do pretty much when it comes to kids, they will allow a child, a minor, to express their preference under certain circumstances. And I don't want to just read it verbatim, but you can see there, that's the text of Family Code 3042A, which really advises the court, and it's the law of the land as to this issue, or one of the laws of the land as to this issue of what happens when a child wants to address the court about who they want to live with. What you'll see is essentially, if a minor is 14 years or older, the court has to allow that child to address the court unless the court finds that doing so, addressing the court, would not be in the child's best interest. And I'll tell you, it might seem at odds. I had a case myself not that long ago where it was a 16-year-old who was incredibly mature, just an incredibly mature 16-year-old. Very sad situation. Abusive father, physical abuse, a lot of sexual abuse. It was really awful. And 16-year-old drafted a declaration to present to the court with her giving her views on what happened and what her preference would be as it relates to even visitation, just being able to see the child. And I vigorously requested that the court allow this minor, this 16-year-old young woman, very mature, to address the court, because the therapist of this young woman actually said she felt it would be in the child's best interest to do so. Finally, this brave child, had this ability to address her father, who had so much power over her for so long, and now he couldn't do anything to her, and she just felt this real strong need to do it. And the court was moved, visibly moved by both my advocacy for this client, but also what the client's words on paper were. And the court respectfully said, Mr. Pollak, I appreciate that. I've read the papers. I think they're persuasive enough. I find that the risks to this minor outweigh any benefit that might come from allowing her to testify. Obviously, I disagreed with it, and the minor did too. But at the end of the day, thank God, the father doesn't get to see this person anymore, and hopefully nobody else is not a good guy. Anyway, sorry for that segue, but the flip side of that is if you're 13 years old or younger, it's not like the court says, well, if you're under 14, you don't get to say anything, and if you're over 14, you can. They'll still allow people under 14 to testify. However, again, they just need to make sure it's just like a heightened standard to make sure that it's in their best interests. And I think that's that's pretty much the deal. I guess a final thing I'd say, just in thinking about this, is some people can say, this is crazy. My 11-year-old's fantastic. They're saying who they want to live with. Why don't they get to decide? And I think in many ways, rightfully so, the law looks at this, and I think everyone would in some ways agree with me when I say, just because children want something does not mean that they just get to have it. If your 15-year-old came to you and said, but I want to eat, Twix bars and gummy bears every day for every meal, it's what I want, we would say, yeah, okay, but you're a child. You're not going to do that. It's unhealthy. Sorry, you can have it every now and then because it's delicious, but you're not going to be able to eat that for every meal. And the court's going to look at a child expressing an opinion in the same way. They're going to give it weight, but they also understand, and it's true, that children of divorced parents, they're very good at playing parents off of one another, even if the parents don't realize that's what's happening. Kids are very intuitive. And you can imagine a scenario where kid wants to go to a party and dad knows mom won't let the kid go. And so dad goes, tell you what, you come live with me. You can go to all the parties you want. I want to live with dad. It's not going to work. I mean, you have to go in there. If there's a fight about this, what you go in, and again, advocacy is so important. You have to explain to the judge why you believe it's the best decision or why you believe it's a terrible decision. And you just put your best foot forward. You've potentially got one shot to do it. There are ways to revisit it, but it's always important to just put your best foot forward anytime something super important like this is at play. At least that's my philosophy. That's my opinion.
Great. Thank you so much. So I'm going to just hop ahead to open forum. The chat is open, so if you have questions, they're going to come directly into me. So please send them away and we will ask Jeff.
All right. Looking for some good questions.
All right. So the first question we have here is from Scott W. And Scott wants to know, I'm not currently paying any child support. If I ask a court for custody and visitation, will this also result in a court ordering child support? Looks like
So he
someone.
wants to know not paying child support and wants to ask the court something having to do with custody and visitation. And the question is, if I go in asking the court to make an order about custody and visitation, are they also going to order me to pay child support? That's the question, Amanda?
Yes.
Yep. Okay. So maybe, I'm sorry for saying it that way. Here's the risk. So first of all, understand you don't just go to court and just ask the court whatever you want to ask the court. Okay. When you file that RFO that we talked about, you specifically state in those papers, this is what I'm coming to court for. And this is what I'm asking the court to enter orders for. If you haven't asked for it in that paper, the court isn't going to give you anything more than you want. And the court's not going to give the other side any more either. So the straight answer is no. If you file a motion and ask for custody and visitation, the court will not enter an order for child support because it's not before the court. And you'll hear judges say that all the time. I'm sorry. Great point. It's a great point you're bringing up. It's not before the court right now. You need to file a motion. There's procedure. You have to go through the process. But what I can say, and is why I said maybe, is if you're not paying child support and you file a motion for custody and visitation, anyone on the other side, what they should be doing is immediately in response to that saying, okay, well, I disagree with your request for custody and visitation, but I'm requesting child support. Thank you for reminding me and putting it on my radar. And now, because you can do that in response to a motion when you're the respondent in that case, now it's before the court because the other party, the responding party, put the issue properly, procedurally before the court. So while it's not an absolute yes, I would be shocked if a represented party didn't ask for support in return.
Great. The next question we have here is from Kristen R. And she would like to know, what's the difference between spousal support and alimony?
This one I can be clear on. There's nothing. It's the exact same thing. It's just two different fancy words. One's a little more fancy than the other, but they're the same thing, essentially. Exactly, actually, not essentially.
Let's see here. The next question is from Roberta. She wants to know, if my ex-boyfriend and I were never married, do we need to file for custody of our kids?
If we were never married, do we need to file for custody of our kids? Well, maybe. This again, now you understand also why I have to say so many maybes, just like I said at the very beginning, where if any of these questions were asked of me with a client that I was speaking to or a potential client, I would have a ton of follow-up questions so that I can, at the end, my answer won't be maybe anymore. Based on just that question, if we're not married and we have kids, do we have to file for custody? It will all depend on whether there's been a acknowledgement of paternity. So in California, there are a variety of presumptions of parentage, which we don't, it's maybe too much to get into here, but when two people are married and they have a child, that child is presumed to be the child of that married couple, whether or not the child is actually biologically both of those parents' children. Under the law, it is presumed to be those child. We can go further and say, if the parents were married at the time the child was conceived and they were married at the time the child was born, they're conclusively presumed. In other words, and there's some exceptions, but unless the mom or the dad in that scenario goes to court to challenge, like do a genetic testing or challenge paternity, nobody in the world can challenge that paternity. The boyfriend, even whatever, they could admit it in person to each other. No one can go and say, you're not the father or you're not the mother. The state of California has a policy that children will have two parents and that it shouldn't be disrupted. It's a very special relationship. It's almost considered like a holy relationship in the eyes of the law that you don't mess with. If you're not married, anyone who has kids will know when you're in the hospital, at some point you get a birth certificate. We're all like crazy when this is happening. And so we may not remember that nurse coming in to have you sign a birth certificate. If you're married, husband and wife's name go on the birth certificate, period. If you're not married, if you're not married, of course, the mother's name goes on the birth certificate. The father, if it's a boyfriend, whoever it might be, does not go on that birth certificate unless they've signed a voluntary declaration of paternity, acknowledging I am the father. They might not be the father biologically, but if you acknowledge you are, then you are. If that didn't happen, then the boyfriend is not legally the parent of that child. So there is actually no need whatsoever to go to court and ask for custody. Mom has custody. Mom is the only legal parent. Boyfriend now has a requirement to go to court and file a petition to establish paternity, to say to the court, hey, I'm the dad. I want rights here. I want to see my child. Or sometimes the mom will want to go to court and say, hey, that's the dad. I want him to pay child support. But you must establish paternity first. So to answer that question, I would say, if both parents are on the birth certificate, then both people are the parents, and he might as well be married. Same process. If you can't agree on who the kids are going to go to, you got to let a court decide. If you're not married and dad's not on the birth certificate, don't bother filing for custody. It's that child's yours.
Awesome. Thank you. And it sounds like we have time for one more quick question before we pick our winner and wrap up. Just looking at what we've had come in. So Ruth wants to know, what's the best approach to regain child custody?
What's the best approach to regain child custody? So I'm going to read into that question and say, because it didn't say get child custody, but regain it. So at some point there was custody and it was lost. This is a hard one because, and I say it's hard because losing custody isn't easy either. Some circumstance, some situation must have happened, or the other side convinced the court it happened and it didn't happen. And sadly, that does happen. But the court must have been aware of something that caused it to say, I know you both used to have custody. You don't get it anymore. I'm providing custody to the other parent. The best approach to regaining custody, procedurally, you need to file an RFO to modify custody. I will say that it isn't always very easy because you need to show changed circumstances. There's some major change circumstance that has happened now, and it's very different from what existed at the time the previous custody order taking it away from you was put in place. So part of it is time. I think it's going to be very hard to show a court that there are significant change circumstances a week after the court found major reason to take custody away from someone. This is a generalization. Maybe all of a sudden the parent who was given custody got into a horrific car accident and is in a coma, and there's no other family member. All right, significant change circumstances. But, in the absence of something like that, I think the best strategy is to bide your time, but with a plan. There's a plan of action. And that plan is, we got to wait a little while. But in the meantime, so that we can show the court there's been significant change circumstances, and typically circumstances don't change quickly when they're significant. So there's like a 6-month plan or a 3-month plan or whatever it might be. And there's a lot of things that are happening so that you can come to court and say, things are way different. For example, if custody was taken away because someone has a drug problem or a problem with alcohol, you start AA meetings, you start NA meetings, you're going to therapy, you're taking parenting courses, you're doing all the things so that in your mind, number one, it's good for you. But number two, hey, I'm going to have to show the court that there's major change circumstances or I'm not going to get my custody back. So these are all the things I'm going to do so I can convince the court, I can show the court, look, things have changed. I'm a different person. Circumstances are different. You got to give me custody back. And I'm telling you, courts want to give that. Courts want both parents to see their kids as much as possible. So they don't take custody away lightly. They're not going to give it back lightly either because they took it away for a really good reason. So you've got to really show them, hey, things have changed.
Awesome. Well, thank you so much, Jeff, for all of your insights during this webinar. Let's see. So at this point, we're ready to announce our winner. So we ask that you go ahead and take a look at your name within Zoom. We've randomly selected someone to be the recipient of 25% off legal fees with Marble. So if you could send me a direct message with your name and email address via chat, I will make sure that you claim that.
It's going in the chat, Amanda?
Yep, just in the chat. And I do have first name, last initial, so I know who we messaged.
Nice.
Awesome. All right, just a couple quick closing statements before we wrap up. So thank you so much for joining our first webinar. As mentioned, a copy of this presentation as well as the recording will be sent. I know we had a lot of questions we weren't able to get to today, but we do encourage you to reach out to hello@themarbleway.com. And I think the last thing worth noting is we are going to be sending a feedback form around because we would love to hear your feedback and thoughts on the webinar, things that you would want to see, things like that. And upon completion, we will be giving you 10% off legal fees in the future with Marble. So that will come through tomorrow. Keep an eye out for it. And yeah, thank you again for joining and have a great rest of your day. Thank you, Jeff.
Thank you, Amanda. Thanks, everyone. I appreciate it.